the respondent number 2 in the original proceeding had deceased 18th of March 2016, and there were 3 subsequent proceedings in this court over the course of 8 years, and in none of those the advocate engaged appeared in this proceeding. And our house is at stake, my lord. And this is our residential premises, my lord. My client has resided in this for over 32 years. The auction purchase was not conducted properly, in which case the matter should go to the DRT, where the parties can resolve their disputes. As well as, my lord, if I may advance a legal argument.
अदालत में एक ऐसे वकील को बहस करते सुना जो मूल रूप से भारत से है, परंतु लॉ की पढ़ाई उन्होंने लंदन से की है। निसंदेह एक नई और दिलचस्प बात है। यह मामला मध्य प्रदेश उच्च न्यायालय का है, जहां एडवोकेट आरिश हैदर, जिन्होंने अपनी लॉ डिग्री लंदन से पूरी की और अब अपनी प्रैक्टिस भारत में स्थापित कर रहे हैं। उनका यूनिक एक्सेंट और तर्क शैली अदालत में मौजूद लोगों का ध्यान आकर्षित कर रही है। इसके अलावा उनकी मजबूत तैयारी और पेशेवर रवैया भी काबिले तारीफ है। यह सुनवाई न केवल कानूनी दृष्टिकोण से महत्वपूर्ण है, बल्कि एक अंतर्राष्ट्रीय पृष्ठभूमि से आए वकील की अदालत में उपस्थिति इसे और भी खास बना देती है। Now let's watch the court proceeding.
My lords, if it may please the court, I appear for the applicants. I am here through virtual conference.
Yes.
Yes. My lord, this is an application seeking to set aside an order dated 16/1 of January 2025 on 2 grounds, my lords. First, that the proceedings had abated when the order was passed. That's a mandatory ground. And on the second discretionary ground, that we were not aware of the proceedings, therefore have shown sufficient cause for being absent at trial. Would your lordships like a brief history of facts before I proceed? My lords, as well as I have in the ERP section provided a written synopsis and 2 other judgments which I will be relying upon.
Who expired? Who died in this case?
The respondent number 2.
When?
She died on 18th of March 2016.
इनका lawyer था. She was appearing through a power of attorney all through. So 10A 2210 A का भी बार है, 2244 का भी बार. But let him complete.
Yes.
जी.
My lord, so yes, the respondent is correct in saying that the petitioner, sorry, the respondent number 2 in the original proceedings had deceased on 1st of March, 18th of March 2016, and there were 3 subsequent proceedings in this court over the course of 8 years, and in none of those the lawyer engaged, the advocate engaged appeared in these proceedings. Subsequently, the order was made on 26th of January of this year, and we found out about these proceedings in the next few days, and we filed an affidavit in support of this. As soon as he found out about these proceedings, we made this application, which is dated 24th of January 2000.
You are not only this review petitioner is not only the power and lawyer as well as successor of the deceased. He is the only successor.
Yes, he is. There are 2 successors, my lords, which we have made.
Daughter. One of the legal heirs is already on record. So, being a legal heir, you are already on record.
I'm not from the documents. I could see that there was a wakalatnama filed, and then there was no correspondence by the advocate, or the advocate appeared on that case.
Not required on each and every day. It is your duty to contact your counsel.
My lord, we were not the counsel in that case. Not in that position, my lord. We were engaged in this case. The client found out about this case, and my lord, we were guarantors.
Why she did not inform this court about the death?
My lords, I was instructed so far that she wasn't aware of this, that the case is still going on because of the advocate concerned had not appeared or informed her of any progress in the proceedings. As well as, my lord, if I may advance a legal argument, there are multiple judgments of the Supreme Court that imposes the obligation on the petitioner to inform the court that there's anyone deceased to prevent abatement of the proceedings, my lord. And there was no application made by the petitioner in this case, which naturally brings us to a position that we should be allowed to defend this case now that we are on record now, and there's been barely any lapse in time, my lord. The matter is still afresh in the minds of this bench, and it would not take too long for both the items to be considered, for the contention of both the parties to be considered. And there's, my lord, a fundamental flaw in the judgment as well, which I have which is impugned in this case. I will not go in vast detail because it's outside the scope of this proceeding. However, this bench set aside the order of the DRAT, which was in our favor, and replaced it with its own order, which deprived us of a remedy to go to the DRT and have the matter adjudicated whether the auction purchaser was a rightful purchaser, or whether the auction purchase was conducted properly. Which again, if we succeed in the DRT, then we would again gain back the property because we paid back all the sums as a guarantors of the in these proceedings, and our house is at stake, my lord. And this is our residential premises, my lord. My client has resided in this for over 32 years, and she had paid the sums due. And the DRAT, they had the powers to decide whether an auction purchase should be set aside or not. And they did remand the case to the DRT to tell the DRT that to adjudicate whether the auction purchase was conducted properly. Now, my contention is, my lord, the auction purchase was not conducted properly, in which case the matter should go to the DRT where the parties can resolve their disputes. This order itself, which we seek to set aside, has encroached upon that right, my lords. And we seek just a chance in this court to demonstrate how that went about. I put forward, my lord, there is a judgment in 1996 in the case of Puran Singh and State of Punjab. I'll just read the relevant paragraph, my lord, at paragraph number 8 of this judgment. It is uploaded in the ERP platform if your lordship seeks to refer yourselves. At the G paragraph, it reads that after the death of the respondent, if the right to sue survives against the legal representatives of such respondent, then the petitioner has to substitute the legal representatives of such respondent before the writ petition can proceed and can be heard and disposed of. It further goes on to say that the petitioner, in this case, that is the respondent now, has to take steps for substitution of legal representatives within a reasonable time. It need not be impressed that it will be of unreasonable on the part of the court to complete the legal representative of the deceased respondent after a lapse of several months or years, and then to direct them to contest the claim of the petitioner merely on the grounds that after the death of the original respondent, the right, title, or the interest of such a respondent has devolved to them. Meaning, my lord, the Supreme Court says that if the petitioner fails to make an application to the court, the inheritors of the respondent's estate, they should not be required to come back 8 years later and litigate over a right which they have accrued as a matter of law, my lord. For that reason itself, my lord, this judgment should be set aside.
Mr. Counsel, you handed over the check of 34 lakhs before the DRT in appeal. Whether those checks were encashed?